Welcome to today's webinar. Please note that the presentation is being recorded and it will be posted online, barring no technical difficulties, of course. Keep an eye on your inbox for the link to the recorded presentation that we will send you by email. A question and answer session will be held at the end of the presentation, so if you have any questions for our panel, please type it in the chat pod located on the right side of the screen and send it to the host. Now, to kick off the presentation, I'd like to introduce today's moderator, Anna Roldan.
Thank you, Laura, and thank you everyone for joining us today. My name is Anna Roldan, and I'm the Content Development Lawyer for the Family Law modules of Lexis Practice Advisor. As Laura said, I'll act as the moderator for today's panel discussion. It is my pleasure to introduce our panelists today, Andrew Feldstein and Ian Hu. Andrew Feldstein is a senior member of the Family Law Bar. He began his career with a diverse legal practice but has been practicing exclusively in the area of family law for over 20 years. He is the founder and principal of Andrew Feldstein Family Law Group, a practice group with several offices serving clients in Toronto and the GTA. Andrew actively supports legal education initiatives. He volunteers as a mentor for the Osgoode Hall Law School Mentor Program, and he is the chair of the Articling Committee at Feldstein Family Law Group. His commitment to education has inspired him to create and host the Ask Andrew Show, a half-hour phone-in question and answer program, which covers various topics related to family law and streams live on YouTube and Facebook. Welcome, Andrew. Ian Hu is the Claims Prevention and practicePRO Counsel at LAWPRO. His focus is on ensuring that legal professionals follow the principles of good practice management and claims prevention. He has spoken at over 100 events, from keynotes to panels, for law firms, schools, societies, and bar associations across Canada. Ian has served as Vice President of the Federation of Asian Canadian Lawyers, where he mentored young lawyers and advocated for diverse lawyers and students. He was the first racially diverse chair of the sole small firm and general practice section of the Ontario Bar Association. Ian has been appointed a leadership member of the American Bar Association's Law Practice Division, serving with several committees, and is the co-chair of Law Practice today. Thank you, gentlemen, for joining us today. Ian, I will let you take it from here.
Thank you. The practice of law of family law is rewarding and can be challenging. Not every challenge can be easily met. And you might feel like you need a lifeline. You might feel like you need some help. When that comes, you can reach out to us here at Claims Prevention at LawPro. The Law Society has a wonderful coach and advisors network that has come into place to help out lawyers when they have questions, specific questions on files, or when they are dealing with other issues. If you get a law practice claim or you feel you have a mistake, you've made a mistake, report it to us, notify us of a potential claim or an actual claim on our website at lawpro.ca. And know this, you are now part of the 4 out of 5 lawyers that at some point in their career get a claim against them. So there are 2 takeaways here. First, if this has happened to you, join the club. You're not unique. It's okay. It doesn't mean that you are a horrible lawyer. You have perhaps made one mistake, and so have 4 out of 5 every other lawyer at some point in their careers. The second takeaway here is we would like to get that lower, and programs like this can help that. Let's look briefly here at a sort of the statistics that we have in the last 10 years. This one's from 2004. And you can see that family law claims have been trending up for the last 10 years. And it's gone up, at the top here you see it's around 200. It's gone up to 250 now last year. So it continues to go up. Lots of reasons for this, demographics being one obvious one. But of course, we're also seeing a lot more unrepresented claimants on the other side, which actually can result in higher claims and higher costs because they will look to the lawyer, you, for advice when, of course, you are not their lawyer. One tip, by the way, in dealing with unrepresented is to always document every interaction, and if you can, try and only communicate with unrepresented in writing. So why are claims going up? There's more stress, there's more costs, and the law is getting more complex. Those are all reasons for higher claims. Here we have a pie chart of the malpractice claims that we see and the reasons for why these malpractice claims arise. This is a global one for every practice area. And you see here that communications, time management, and inadequate investigation are the top three. The lesson here is that practice management issues tend to be the highest causes of claims. It tends not to be error of law. Although if we look at family law claims, you'll see that communications remains number one. It means that lawyers need to communicate better with their clients, and we'll talk a little bit more about that. And number two is error of law because the law is always evolving in family law. This is followed by time management, which includes missing deadlines and not completing tasks on time. Inadequate investigation, which includes issues like not interviewing your clients properly and getting all the information you need to. For example, you know, where do your clients have kids from one family or another family or from more than one, and so on. Clerical issues, which is delegating properly, and then conflict of interest. Okay, so let's start with talking about communication errors.
Okay, in my practice, I find communication with clients is essential. And how we do it is frequent and regular updates to the client. What does this mean? This means if I have a phone call or a meeting with the client, I take very detailed notes of what took place. At the conclusion of the meeting, a lot of people will do it themselves. I usually have one of my staff do it for me, but the client will get a confirming email of what we outlined, what steps we're taking, what steps we're not taking. That way the client has an email, and we have an email saved in the file where we've communicated with the client what our plan of action is. And I believe it's really critical to do that at each and every stage of the file. Generally, in my mind, when I think of effective communication, it includes clarifying expectations. And that means when I'm in a meeting with a client, I'm not sitting there as a cheerleader because I always have my hat on, picturing myself in court. And if I am not successful, I see the client when we walk out of court saying to me, Andrew, how come you spent all this of my money to end up here and I'm not happy with the result? So it's really important to manage the client's expectation. And we do that first in those meetings by telling the client, this is our position, but it's not black and white. It's not clear. It's not a surefire winner. It's a maybe. And the nice thing in family law is most things are maybe, other than if someone is a T4 employee paying table child support. So warn the client. And that's why after the meeting is over, warn the client again in writing. These kind of warnings and communication with the client is what will protect you when the client is disappointed with the result and the client says to you subsequently, I'm not happy with the result, I'm going to assess your account, or I'm going to sue you, or I'm going to do this to you or that to you. You can actually go back to your file and send the client the confirming email, remind them of your meeting, and perhaps you may have told them the same thing 2, 3, 4 times. That does a lot to calm down the client. Most likely the relationship will be at an end, and we'll discuss that later on. But the point that I'm really getting at is this is a way to make sure that the client realizes you have fulfilled your obligations by managing their expectations, and you haven't promised them something you can't deliver. One of the other things, and I'm probably the people who know me well would say I'm not great at is active listening, because I probably interrupt people too often. But active listening can be really important when you're meeting with clients. In family law, when someone walks into your office, for most people going through this process, it is all consuming. They talk to their friends about it, they talk to their families about it, their former spouse gets them angry constantly, all the time, and it is all consuming for them. And you need to manage the process in that you need to engage in the act of listening so that you hear them and they feel heard, but also balancing it with what you're charging them to listen to it. And there needs to be a balancing act there, but it's very, very important for the client to get the feeling that you understand them, that you appreciate their concerns, even if it's not necessarily relevant to their case. I mean, the best example of that, when a client comes in and they tell you their former spouse was having an affair, really important for them to get off their chest and say it. May not be so relevant to your case, but it's really, really important for us as lawyers to hear what they're saying, appreciate what they're saying, and express the empathy that they need to hear. Now, moving on from communication with clients, I think of every case starting from that first meeting when the client walks into my office and we do a consultation. And I remember years ago, it used to be clients frequently decided on the spot whether they're going to hire us or not hire us. Now, I find that happens far less often because there's more beauty contests of clients choosing to interview 3 or 4 lawyers before they select the lawyer they want to hire. What becomes very important is ensuring that the client who walks out the door doesn't believe that you have an obligation to them to start working on their file. You will think, they never signed a retainer agreement, they never gave me money, so why would they think I have an expectation that I'm starting work on their file? Except if something untoward happens to them or they miss a limitation date, they're most likely going to blame you because you're a convenient target and you have something called insurance. So in my mind, it's really important to deal with that. And the more things that you can deal with in an easy and simple fashion right there when you're meeting with the client, the better it is. So one of the things we have all of our clients do is at the end of our initial consultation, unless the client is hiring us on the spot, we get them to sign a non-engagement letter. And we have them confirm that we're not hired, we're not taking any steps in the file in any which way whatsoever. We're not doing anything for them until they've signed a retainer agreement, a written retainer agreement, and in addition, they've provided the agreed upon retainer. Probably about 95 to 97% of our clients willingly sign the document. That makes us feel good that we've had the non-engagement letter signed. Every so often, a client refuses. Every so often, a lawyer may forget to ask the client to do it. And the way our system works in our office, we will typically have someone review the forms to make sure at the conclusion of every consultation it's been signed. And if it's missed, we then send a confirming email to the client and we attach our non-engagement documentation that we would have them sign and confirm that we're not retained. The other place that I find this is really important for is limitation periods. Because I'm always worried someone is going to say they came into my office, may have been right after the separation, and 6 years later they never made a claim for equalization, and they're going to blame it on us. And they're going to say, well, I asked Mr. Feldstein about limitation periods, and he said don't worry about it. So when we get our non-engagement letter, we actually break it down and we say all the limitation periods for property. We talk about the different limitation periods for trust claims. And in addition to that, we even warn the client that there can be an argument about the date of separation. So don't sit there and think just because I think I separated in 2018 that it doesn't mean my spouse may not argue it's 2014. Really important to put all these points in mind, because if you do, that client that you met with that never hired you won't be suing you out of an expectation of work or that you didn't give them any advice with respect to limitation periods, albeit we're not giving them advice, we're giving them information. So I should correct myself on that comment. On the next slide is an example of one of the situations when we send out a non-engagement email or letter to the client. So at our firm, we would only send this out when the prospective client refused to sign the acknowledgement we have them sign, or if one of us erred and forgot to get them to sign it. So that's our catch-all to solve any problems we have with respect to errors. Now, I touched on what's on this slide before, but there's a lot of things to think about here. That when you consider providing a client with written confirmation, we like to think about sending written confirmation of firm policies and the scope of services. So I always picture the end of the case, like I said earlier, when the client complains. And when you think of the end of the case, what the client complains about, I've been doing this for 25 years, almost 25 years now, and it means I've experienced a lot of complaints over the years, angry clients over the years, people who want to pick holes in what we do. And every time you have a client complain about your documents or your precedents or they didn't understand something, it's one thing that you're going to naturally be angry, but the other thing is look at it as an invitation of how to improve your documentation to avoid the next person who's going to have that same complaint. So we have a memorandum here, and what the memorandum is, it's a document that we have our clients sign at the same time that we have them sign their retainers, because we want them to understand the information and not say they didn't get it. So our memorandum will tell clients how we charge for our time, how fees are calculated, what our bills will look like, how often we're going to invoices, what are disbursements, what may be charged to the client, and the general rate. So the client knows what the hourly rates of all the lawyers are. They know what we charge for photocopying. They know that we may hire other people for disbursements. This way they know it, and they've authorized us for this one. The next one we have on our slide is how the firm handles settlement funds or proceeds of sale received in trust. Now this is, I sort of call this my catch-all. People who know me know I look at things from a business perspective, and even though I like to have retainers in all my files, every so often you may not. So in the memorandum and or the retainer, I think it's a really good idea to include a direction that the settlement proceeds from property or sale of the matrimonial home get paid into your trust account ultimately. This is a way to protect your fees. We talk about the firm's confidentiality and privacy policies. I think this is a really important one because a lot of people do not appreciate that when you are sending confidential emails with confidential information in it, it may very well not be a secure communication. So we actually get the clients to sign an acknowledgement that when we are communicating with them via email, that it may not be secure. This way they know about that issue and can't be upset about that. We also like to make it clear what are the limitations on our scope of what we are going to do. We make it clear we are not tax lawyers, we are not tax accountants, we are not CPP experts, we are family law lawyers, and that's who we are and what we do. So we want to make sure that the clients understand that, and my paranoia also stems from getting my clients to either get independent legal advice and signing our retainer agreement and our memo, or an acknowledgement that they've been offered it and they've declined it. We deal with when our retainer comes to an end. So all of these points to me are very important because they're ways to make it clear in terms of your interaction, your communication, what your role is between you and your client. At the end of the day, you hope that you don't need to look at that with a client, but when you have angry clients, I find the retainer agreement that we use and the memorandum we use are the first place that I'm going back to look at. In fact, our memo even talks about financial statements, and it's the client's responsibility to make sure the information they're providing us is accurate and correct. And this gets into the next slide, which is the memorandum to the client. The retainer's there, the fees are there, like I said, disbursements, how we deal with unpaid accounts. This gets back to expectations. It's important that clients have expectations that they're going to pay. If they don't have expectations they're going to pay, they probably won't pay. And to me, that's an important thing. Receipt of settlement funds and proceeds we've discussed of the home. Confidentiality is very important. Clients are more and more concerned about that every day, and they need that comfort that you're going to be dealing with that. And we talk about what our obligations are with respect to documents. We try to be a paperless firm, save and except for the continuing record and the final separation agreement or minutes of settlements, So we are notifying our clients that there's a certain time period we will be destroying all of the hard copies in the file. And if they've given us original documentation, they're being put on notice that there will be a destruction date of that documentation. We will maintain an electronic copy of the file, but again, it's making sure the client has knowledge and has signed off on it. As I mentioned earlier, this is trying to take, you know, every time we work on financial statements with clients, the client will want to look at us and blame us for any mistake in the financial statement. It's the lawyer's fault. We should have known that they had certain assets somehow. We didn't explain it to them. So this is why in our memo, we throw the onus back on them. This is their life. It's their knowledge. It's for them to tell it to us, and they need to take responsibility. So that at the end of the day, if the client is going to blame us, we can point them to this document which they've signed and initialed each page dealing with that. There's another opportunity. We mention cost consequences and explain offers to settle. Again, it's a catch-all. We will frequently discuss this kind of issue and disclosure with the client throughout the file, but in my mind, it's a really good thing to have told the client that right at the beginning. It's an ability for us to say we put the client's mind to think about issues of offers, and we've told them about the cost consequences so they understand it from the get-go. They can't say later on, had you told me about this earlier, I would have managed the case differently, because that's what clients like to say. Well, no, we told it to you at the beginning. They know it. It's clear. They've signed for it. They've initialed the page. We talk about the conclusion of the retainer. We deal with what happens of non-payment of fees and issues like that. And again, disclaimers on pensions, on tax, on corporate, on estate advice. Because we as family law lawyers, we're used to wanting to help our clients. And we want to do the best that we can to help our clients, but we need to be careful to know who we are and what we are. And when something comes up that's beyond the scope of our abilities, that we tell the client to go get somebody else who knows what they're doing in that area, because that's not our area of law.
Excellent. Thank you.
Another large area of claims in communications is the failure to obtain consent or to inform the client about what you're going to do. This is an area where you're going to have to use your best judgment. Just because, I mean, it doesn't mean that you have to tell your client about every single step that you're doing. You know, you got a motion coming up. You probably don't have to tell your client, well, I'm going to file a notice of confirmation form, and on that confirmation form, I'm going to put on these 3 points. So you're going to have to figure out what's important to your client. What costs are they looking at that's going to be affecting them? What steps are important to them? And Andrew's going to talk more about that in this next slide.
Okay. A theme you may hear from me is I'm paranoid. And that means I like my clients to approve of just about everything. So unless I'm sending out an email or a letter that says, enclosed herewith, please find my client's sworn financial statement, I am probably going to get every email and every correspondence that leaves my office approved by my client before it goes out. It may sound like an onerous task, but clients like to know they're involved. They like to be in, you know, it gets back to the communication, and the 41% of lawyers are getting sued because of lack of communication. It avoids the problem of the client saying, you took steps without my permission. Because each and every time we've received our client's permission, and there's times when we've sent something out and the client says, I don't want to make that offer. I don't want to take that position. I want to change my mind. It's a lot better that I have the client sending in, yes, I approve that letter to go out, rather than it being a conversation with me and the client saying, sure, send it out, and then I send it out, and the client says, well, I didn't tell you that on the phone. So you really need to make sure that you're sending and getting approval from the client on anything substantive that you're doing on the file, because that's the best way to ensure that the instructions were clear and that you had the client's authority to do it. And that way, when it comes to miscommunication, it's not a miscommunication. So email is wonderfully effective for that. I know I have a great team at my office, and I know a number of them are listening, and they know they usually do these emails instead of me, but it really is important. The other thing I think is important is copying the client. Whether you want to copy the client on the emails to the other side or forward it to them after you've received the emails, have the client see all the communication between you and the other lawyer. It's important for a few reasons. Number one, it's making sure they're involved and they know what's going on in the file and they appreciate the communication. But the other thing it deals with is sometimes clients come in and say, I was with another lawyer and I didn't like how he was talking with or she was talking with the other lawyer. They seem too friendly, they seem too chatty, they communicate by email and they don't include me. If you're very transparent and the client sees everything, then what happens is the client knows what's going on and they're more comfortable. The other thing it does, getting back to billing again, is it makes the client feel more comfortable about their account because they have something to see for it. When you're not communicating with your client and the client doesn't hear from you and doesn't see every step you're taking, they have less appreciation for the value of your work and what you ought to be paid. So it helps you from that perspective as well. When you're doing these confirming emails, it's really important to confirm not just what you are going to do, but what you're not going to do. What do I mean by that? Well, let's take the example of I recommend to my client who is self-employed that they ought to retain a business valuator to do an income report. And I'm going to tell the client I think they need it, I think their case is going to have a lot of problems, and I'm going to predict what's going to happen. And when the client hears the cost, they say, Andrew, I don't want to pay it. And I have a bit of an argument with them, and at the end of the day, they're the client, it's their money, they're going to prevail in that argument. But that means they're going to get an email from our office where we're going to say, we clearly recommended this to you, we hope that you will reconsider, but we're confirming that you do not want us to hire a business valuator at this time. When you do that, you are now protecting yourself for when you go to court, and the court may hit your client with cost consequences or order your client to do it, and the court's disappointed that you've wasted their time by not doing it at that stage. You've communicated to your client what should have happened, and the client is the one that has to take responsibility for that result and not you. So that's an example of confirming what the client should be doing, even if the client isn't doing it. And always, always, always when receiving instructions, do a memo, send an email to the client confirming it, because that way there's a record of it. I know Ian will get into what happens when you don't do it, but I can tell you right now, you are asking for problems.
And so the flip side of this, of doing something without getting instructions, is getting instructions and not doing it. And this is failure to follow the client's instructions. Very important when the client says, you know, they want the house and the dog and, you know, and the classic car, that you try and get those three things for your client, and you're not, and instead you're not busy focused on getting the cottage and the finances from the business and so on. You let those go. So when the client gives you instructions, when the client gives you what the priorities are, you want to make sure you document it. And here's the issue if you don't document it. If, let's say, you get instructions and it ends up, you know, you didn't go after the pet, and you should have, and the client had told you many times. Here's what's going to happen. Let's say that this goes to, the client sues you for not trying to get the family dog. You end up potentially going to court, and there's going to be two witnesses. The first witness is going to be your client, and your client's going to go up on the stand and in all likelihood will say, I have had one lawyer my whole life, and it has to do with this case. And I've met this lawyer twice, you know, once at intake and once leading up to mediation. And I can tell you exactly what happened those two times that I met that lawyer. I can tell you every single word, in fact, because I remember it very clearly. It's the most important thing that's ever happened in my adult life. And you know, you can already sense that that's going to be that client is likely going to have some pretty good credibility in front of a court, at least at first blush. And how about you? You go up there and you say, well, you know, in the last 3 to 5 years, I've met hundreds of clients. I don't actually remember what happened when I met this particular client on those 2 occasions. I can tell you that typically I do this and this and this. So you can already see how that's going to go. So it's very important to document your work. I've got a nice little slide here. Let's see. There we go. Boom. So keep calm and always document your work. Now we're moving into the second or third most, in family law, this is the second most common area of malpractice claims, the failure to know or apply the law. And Andrew, you want to start this off?
Sure. You know, there's certain things that are easy to take care of, and there's certain things that you got to know what you don't know. So I look at the one at the bottom that jumps off the page to me right away is liability on mortgage events after separation. It's really simple. When you act for someone and they're selling their interest in the home, usually it's the matrimonial home to the other party, and they're on the mortgage. In our agreements, we typically say that the other side will give them a release from the mortgagee. At that point, I view it, we've discharged our obligations, but we need to tell our client we're not real estate lawyers, and we will forward a copy of the agreement to the real estate lawyer who's going to be doing the transfer, but telling them get another lawyer to do the transfer, and we will report to the client and tell the client that it's their obligation to get that release and not for us to do it and for them to do it with the real estate lawyer. It's no different than tax obligations. I'm a family law lawyer. I'm not a tax specialist. I'm not an accountant. So I'm not going to give tax opinions to a client. And that's why, as I said earlier, we put it in our memo. Don't change it. Don't start giving tax advice. Tell the client you have tax obligations. Go get advice for it. I mean, we can all read our divorce-mate forms and know what's going to happen with spousal support, but if they need any real tax advice, you send them off to an accountant or a tax lawyer. It's not our role, it's not our responsibility, and don't give in to a client who says, oh, but you're a lawyer, don't you know the answer, can't you do this for me? And then you get this sympathetic feeling to try and help the person, and a year from now you might be spending more time with some of Ian's colleagues at LawPRO because you made a mistake on something you don't know about. So don't overextend yourself that way.
You know, it's also important to, you know, there's lots of solos and smalls in family law practice. It's very important to build yourself a network. And if you can't, you know, go to conferences, join sections like the OBA's family law section, and get CPDs, and stay up to date with the law. The first 3 boxes there, there's nothing to say about that except that you got to stay up to date. So that leads us to our main point here. When you're dealing with an issue of law that's outside of your expertise, you got to recognize that. Let me talk briefly about tax issues. The main source of tax law claims when it comes to family law isn't that, for example, the family law figured out that there's a tax issue and got it wrong. It's that the family lawyer didn't identify the tax issue to begin with. So you got to see that something is just not within your ambit and say, you know, this is a tax issue. I don't know what it is. I don't know if there might be, but there could be. Well, that's when you're saying go see a tax accountant or go see a tax lawyer. And here on this slide, I've got some, you know, some options here. If your client is disturbed and is unhappy and clearly has some psychological issues, you know, recommend them to go and get some help. Other places you can refer them to are of course, the tax accountants, whatever banks are necessary, an employment lawyer if necessary, and so on. Okay, so the number 3 most common malpractice claims area is inadequate investigation or investigation of facts. This is when you are interviewing your client, let's say at intake, or anytime you're trying to get information from your client. Make sure you identify all assets and liabilities, and you know, the clients might not be willing to tell you everything, and you got to say, look, you want me to do a good job for you, you got to tell me everything you have. You got to tell me how much it is, how much you have in each asset. Otherwise, I can't do a proper valuation for you. And while you've got your calculator out, and you're trying to piece together, you know, the income from a business, for example, again, realize when this might be outside of your expertise. When a calculator isn't enough, you might have to get yourself a business evaluator or someone to figure out how much an asset actually is worth.
I just want to, before I get into the slide that's currently posted, I want to add one thing to what Ian just said. When I'm in meetings with clients and they will have filled out a form and I will go through it with them, I believe in constantly asking the same question if you don't necessarily believe the answer in a slightly different way. So when someone says, well, I have a bank account, well, is that every bank account? Are you sure you don't have another? If you see they have a property outside the jurisdiction, are you sure you don't have a bank account in Florida if you have a property in Florida? Oh, yeah, I do. Do you have an RSP? Do you have a TFSA? I find probing is really, really important. So don't just accept the answers that are given to you by the client when it comes to assets and liabilities and incomes. And when you want to challenge your own client on that, there's a way to go about doing it so it's not insulting. And you say to them, as a good lawyer, it's my job to try and anticipate what the other side is going to do. And if I was the other lawyer, I would be asking the following questions of you. And then sometimes I get them say, oh, yeah, you're right. I forgot about this account or that account, or I didn't appreciate that if I have property in the country I originally came from, I had to include it. So don't hesitate to probe and dig and try to get to the information. Now, on the form, that next one is back to the initial consultation. There's certain things here that we do at my office that I think are really, really helpful, and I find I go back to my initial form all the time. I mean, the easiest one I start off with is we have obligations as lawyers for identification and verification. So I like to get that done before I've even met the client. So by the time I'm meeting with the client, I have their license, I can look at them, and on my form I can tick off that I've identified, I verified. Because there's multiple lawyers in my office, I put my initials next to it, and I'm picturing when the auditor from the Law Society is out at my office the next time they decide to audit and they want to see did we identify and verify, there's a record there that we've done it, and we have a copy of their ID. It's obviously clients need to have the communication that's confidentiality and that it's private. Punctuality is important because people are coming in, they're assessing us and how we are as lawyers. But we also have to assess the client's circumstance. What's their competency? What's their mental capacity? What's their expectations, their needs, their objectives? I'm sure for everyone on the line, there are clients that we have all accepted that if we could do it over again, we would not accept. So it doesn't mean that you accept every client, but obviously you do want to make a living and you want to accept clients, but you need to turn your attention to those particular issues. And if someone is behaving in a way that you question their competency or ability to have capacity to give you instruction, better to deal with it here than later on, because a problem only becomes a bigger problem going forward. So when you have that initial consultation and the person is a real big problem, better to deal with it now, because it will only be a bigger problem when they become a client. And I can tell you from experience, sometimes you do get some problematic people at that stage, but better to get them out the door. We have to deal with third-party payments, deal with it up front as soon as you can. Standardized questionnaire. Really, really, really important thing. Don't go into initial consultations with a notepad, because if you do, you're going to miss important information. When we go through our questionnaire, we will typically get a lot of important background information that we can use when drafting the pleadings if we need to do a pleading or a separation agreement. But you also, as I said earlier, you need to be careful that you're providing legal information and not legal advice, because we're not being retained, we're not providing legal advice, and in fact, when we get the acknowledgement, that's one of the things we include in the acknowledgement is that we did not provide any legal advice to the client and it was just legal information. You need to confirm whether you've been retained, and I like to come up with a list of tasks for the client to complete if they hire us. Getting us the financial statement is for one, tax return, notice of assessments, those kind of things. Then as part of our questionnaire, we call it the matrimonial information sheet. This is where we get the information on who is your spouse, and not just the name. We want their birthday. We want your date of marriage. We want your cohabitation date. We're trying, in my mind, I'm looking at and thinking, if I have a payor there, you know, I'm always thinking about the rule of 20 or rule of 65 for spousal support, because alarm bells go off in my mind. If I'm seeing the payor, my heart goes out to the poor person who has to pay indefinitely and don't get a fixed termination date. If I'm acting for the recipient, I think they have good fortune that they're going to be getting indefinite, most likely. Need to know whether there's litigation, when they separated. Date of separation is critical for limitation dates. I'll never forget when I had a lady walk into my office at 5 years and 364 days after her date of separation. And I was really happy that that meeting was at 10 o'clock in the morning, because later that day she had an application issued with a claim for division of net family property. So you can imagine how important it was that I asked her date of separation, because that was critical. If I didn't ask that one piece of information, I would probably be seeing one of Ian's colleagues. I want to get the employment information from both parties. I want to know how much they make. I want to know the structure of their pay. Do they get bonuses? Do they have stock options? Because that all plays out into how the case is going to unfold and relevant issues for support. Residency, and actually it's not on this list, but I like getting citizenship. Residency is obviously important for, can you commence in Ontario an application for divorce? Is this the right jurisdiction? But if someone is a U.S. citizen, a lot of people don't realize that is an important question to ask, because if your client is a U.S. citizen, their TFSA, which stands for tax-free savings account, is not tax-free, because they will have an obligation to pay U.S. tax. If they're a U.S. citizen and they're on title of the matrimonial home, they will have to pay taxes when they dispose of the matrimonial home to the U.S. government. So these can be really important pieces of information for notional disposition costs. So I like that information. I want to know how many children. We get into information about parenting. Do you have concerns with the other parent? Are there issues about religion? I want to have that kind of background information, because it's telling me, some of the messages are, is this a high conflict file? Is this a money file? Or is it a parenting file, or both? I ask about marriage counseling, and I ask who they've had and whether or not it's helpful, because in my mind, I'm thinking, ding, 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 I've just satisfied one of my obligations under the Divorce Act, and I have proof of it. I want to know, are there existing agreements, because if a client doesn't, it's unbelievable if you don't ask this specific question. A client says, oh yeah, I signed a marriage contract. A little bit important for us to know, but clients may not tell us that. I want to know, do they own the matrimonial home? Do they rent it? Who lives there? Because some clients won't have that information, or some clients will give you information, but it's really important to understand how much money is in the home, who's living there, not just is it your client, who's on title. There's issues dealing with debts. What debts are owned? I want to know about exclusions. I want to know if there's life insurance. Life insurance can be critical if someone is ill. So this is an opportunity where you really need to get a lot of the background information, and it's a good place to always come back to.
Thanks, Andrew. Ian?
So time and calendaring errors is further down the list for family law, but ever so important. There are two kinds of errors that this covers. The first is missing deadlines. The tip I'll have on setting your ticklers is if you can, you tickle more than one person. You tickle both you and your assistant, you and your receptionist, you and your law clerk, you and your junior, you and your student, so that more than one person can be alerted. And of course, with ticklers, you want to set them at good sequences well beforehand. 1 year, half a year, 90 days, 60 days, 30 days, and then, 2 weeks, 5 days, and the day before. The other issue is procrastination, not completing tasks that you should be completing on time or in good time. This is a practice management issue. And one of the tips that I have, and I'll give you some practice management tips here, is to put your to-do in your calendar. So some of you might have a to-do list, right? And you go through that list in Outlook and you slowly check them off. But another way to do it is to put all of your tasks in your calendar as appointments. And so you either get around to those tasks that day, and which are appointments, and if you don't, then you set another appointment in the future to do it. If you work in this way, you're never going to miss a task because essentially they are appointments in your calendar. Another practice tip: you walk into work in the morning. What do? You start reading your emails, and then how do you figure out what's the first thing you're going to do? One way to do it is you take out a sheet of paper and you put on that sheet of paper the top 3 things you want to do. When I was practicing, if I was able to complete those 3 things or those one thing, usually even one thing was like great. If I can finish those by 12 o'clock, I've had a good day. So those are just some practice management tips here. Okay, let's go on to our next slide here. The bad client. So there are all manners of difficult clients. And I'm going to start talking with the previous lawyer's issue. If you get a client that's had one previous lawyer, and maybe that's just because they didn't get along, and that's fine. You'll give this client a shot. But if the client has had 2 or more lawyers, that's usually a warning sign that maybe it's not the specific relationship between the client and the lawyer. Maybe this client is going to present problems for me too. So consider that a warning. And Andrew, I know you've got a lot to say about these issues.
Well, I know we're short on time, so I'm going to try and run through it fast. You need to understand difficult clients are hard to please. They can be needy, they can be helpless, they will demand a lot of time, they're not going to want to pay for it. So you need to be clear, deliberate, and straightforward about your role. I know I've talked about confirming everything in writing, but when you got these kind of clients, you got to go to the nth degree of confirming everything in writing and thinking about how picky they're going to be. I remember once I wrote a letter that said, please feel free to contact me if you have any questions, and that picky client called me up and complained that I billed him for his phone call because he said I said free to contact him. So that's how far people can go to be that way. So I have never put in any language, please feel free to contact me again. So think about the words you use when you're communicating with a difficult client and manage their expectations. But when you're managing the expectations, don't talk about the best case scenario. Focus on the worst case scenario and hammer it home, it's the worst case scenario. If you're ever in court with a really difficult client and you know you got a good draw with the judge that you think will be favorable with the case, don't tell the client it's a good draw. Make yourself the hero at the end. And if you have a bad draw, be very clear to tell the client it's a bad draw, and if you're talking to any other lawyers at court, get them to join in on the conversation so the client can hear it and it's not just from you. These are little things that can be done to set the stage in advance. But you need to remind the client you're on their side, and you need to be able to draw the client to the conclusions the way you want them to, but you have to do it in their language. Clients are usually very sensitive about money, and when they're telling you, these difficult clients, to do foolish things, you need to tell them, this isn't in your best interest. I'm going to lose. If I lose, you're going to pay for me, you're going to pay for the other side. And I'll frequently say to them, do you have a fireplace? And they'll say yes. I say to them, then I want you to go to the bank, take $20,000 cash out of the bank, turn on your fireplace at home, and start throwing the bills in the fireplace, because that's more fun than what you're going to get out of paying me to pursue what you want to pursue. That's when the light usually goes on. In terms of termination of the retainer by clients, a client can terminate our retainer at any time without cause. And sometimes I call it the happy dance, because when it's a difficult client, I'm through the moon that the client is not a client anymore. But when that happens, make the transfer of the file fast and efficient and easy. That client's already angry at you because they're switching from you. Make it easy so they won't be angry. You don't want to invite an assessment, or you don't want to invite a lawsuit. When we want to terminate the retainer, it's not as simple as when the client wants to terminate a retainer, because a lawyer can't withdraw from representation of a client except for good cause and on reasonable notice to the client. Good or justifiable cause is a serious loss of confidence between the lawyer and the client. If we're deceived by the client refuses to act upon our advice on a significant point, so it can't just be, I think you need to do X, and they say no. They get to make the decisions unless it's something really critical. Not paying enough of a retainer, that depends on the timing of the file, so don't get caught where you got to do a trial and you don't have any money in your trust account. A client that's persistently uncooperative or unreasonable. The client, I had one client who would come in and he would yell at my receptionist. He'd be fine with me, but he would yell at the receptionist. So because of the size of my firm, I have a workplace harassment policy, and in my motion to get off the record, I referenced my obligations to my workplace harassment policy and my staff because of how unruly he was to them. So you can use things like that. You need a breakdown in communication, and if you're not competent to continue on the file, that's one I certainly wouldn't be that proud to admit if that was the case. But at the end of the day, if you have a difficult client, you may be stuck doing a trial with them, but if you want to get off the record, you need to do it early, you need to deal with it early, and you need to make sure the client is aware that you're bringing your motion to get off the record. When the client agrees and consents to the termination, get the notice of change to the client that day. Don't wait. The client may go talk to somebody later that day and change their mind and make you bring the motion. Don't wait. Get it to them. Tell them to fax it back to you. Put the original in the mail. You'll serve and you'll file it. It's well worth the investment of getting off the record rather than being expected to go to court for something you don't want to go to court for. When a client opposes the termination and you're on the record, you're stuck going to court. This is one reason why I think limited scope retainers can be a great thing, because when you're on a limited scope retainer, you're not on the record, you shouldn't be able to be forced to go to court. And I wouldn't be scared to do them, but be very clear in your retainer and your engagement letter what the scope of the arrangement is. When you're thinking of getting off the record, you cannot abandon the client, so you can't get off the day before a motion unless it's the client who wants you off. So you've got to be careful to monitor the timing. Ensure that the client knows what their obligations are when you're getting off the record. I know we're just about ready to wrap up now, but one of the critical things I like is reporting letters. It's your catch-all to explain why you made certain deals and to make it clear it's the client's obligation to chase documents down. Like I said, the release on a mortgage, put it on the client. If you're supposed to have an irrevocable beneficiary of a life insurance policy and the other side is supposed to send it, confirm in writing to the client that it's their responsibility to get it. If you got a release of spousal support, say in the reporting letter, I warned you that releases can be set aside. This is a great time to put all of those last and final things in so the client has a written record of receiving it.
Excellent. Andrew, Ian, any final concluding thoughts on difficult clients or reporting letters?
No, those are all wonderful comments.
Okay, excellent. So thank you very much, gentlemen, for a very enlightening presentation. Right now we invite our audience to submit some questions to the host, but while we collect those questions, I just wanted to quickly take a moment and show you our family law module of Lexis Practice Advisor Canada, who's of course the sponsor of today's webinar. So Lexis Practice Advisor, or LPA for short, is a practical guidance tool. It's designed by lawyers for lawyers, and it's meant to provide practitioners with a how-to, step-by-step guide with the information they need to better represent their clients, error-proof their workflow, and carry out tasks in a time and cost-efficient manner. So really the goal of LPA is to answer the how questions of legal practice rather than the what questions of law that you would get with more traditional tools. So right now on your screen you're seeing the Family Law Ontario module of Lexis Practice Advisors, although we do cover 14 different practice areas. And as you can see, there's quite a few topics covered. Core aspects like custody and access, financial disclosure, procedural issues like litigation and ADR, and niche topics like estate issues and bankruptcy and family law. So here you'll see I've expanded into one of our topics, and you can see there are, each subtopic contains various results-oriented documents like practice notes, precedents, and checklists, each of which is useful depending on a particular task at hand. So going back today, our presenters gave an example of the importance of obtaining information, including financial disclosure. So let's go into the financial disclosure topic. Under completing the financial statement, you'll see 20 practice notes that provide you with the procedures and also the substantive information, as well as checklists about managing clients' expectations in connection with financial disclosure, and a checklist about you completing the financial statement and making sure everything is in there, and common mistakes to avoid. And finally, today, Andrew discussed a lot about making sure that you give your client everything in writing. So here we have an excellent memo that talks about the importance of accuracy in the financial statement. So you'll have given this information and advice to your client, and then you can download it, personalize it, and email it to the client. It saves some time. One of the great aspects of LPA is that we leverage the knowledge and expertise of experts in their field of practice. Other lawyers, for example, Andrew Feldstein, is a contributor to LPA, and he's created our practice management subtopic, which we discussed today. He talks to you about the importance of obtaining information through the initial consultation, and here is Andrew's matrimonial information sheet loading with all of the questions that you would need to ask clients to make sure that you don't miss any of the details. Andrew also discussed the importance of confirming to a client general firm policies, and that extensive memo will be part of the handouts that you receive with your thank you email from us, so keep an eye out for that. And finally, the discussion about keeping abreast of developments in the law and knowing the law. Another neat feature is that we have legislative updates. So for example, in September, there was a quick minor update to Rule 24 of the Family Law Rules, but back in July, there were extensive changes to several family law rules, and so we've created a comprehensive update to show all of that information. And there are many other neat features, and with your thank you email, you will be able to request a free demo. All the information will be there. Now I believe we've gathered all of our questions, so let's get started on those. So first question, given the comprehensive nature of your matrimonial information sheet, do you send it to the person ahead of time, or tell them to expect it, or tell them to expect to come in 30 minutes early and fill it out? Andrew?
Great question. We tried sending it to people in advance in electronic form. That was a failure. Most people didn't bother filling it out. We ask people to come in early. Most don't come in early. So we schedule our consultations for up to 1 hour, but it goes in my calendar for an hour. If someone shows up for a 10 o'clock appointment, they'll fill it out, and it just means, oh, my cutoff time is still going to be my cutoff time.
Excellent. One of the other questions we have is, what is a good place to locate forum precedents in addition to LexisNexis? Ian?
So practicePRO has publicly available free resources. For limited scope representation, we have checklists, retainers, handouts. It's available at practicepro.ca. And if you want the specific link, it's practicepro.ca/limited scope. We also have fact sheets for family law. So if you're wondering, where are the family law mistakes coming from, and we have it all on one sheet at practicepro.ca/fact sheets. And we have a domestic contract matter toolkit, which has an intake form, checklist, and so on. And that's available also on practicePRO.ca, along with other retainers and other firm policies.
Excellent, thank you, Ian. And I'd also like to mention that we will be sending the family law malpractice claims fact sheet along with our thank you email. And a lot of the links that Ian mentioned now are linked there, so you won't even have to look very far. It'll all be in one place for you. Okay, next question. These extra measures to protect against potential claims, for example, emails to clients, post telephone calls, cost the client money. How does one achieve a reasonable balance between clients' cost expectations and responsible documenting? Excellent question. Andrew?
In my mind, it's very simple. This is what I do on every file. This is part of what I'm going to charge for. And you need to appreciate, go back to what Ian said earlier, 41% of claims against family law lawyers are because of lack of communication. A client, when they meet or talk to us, feels a lot like it's a doctor's appointment. When you walk out, you don't remember what the doctor said. So they appreciate getting the confirming email. They appreciate that because they know during the call after they get off, they're going to get something that confirms it. So I find most clients actually like it and are happy about it, and because that's our policy, there isn't any question about fees.
Do you ever create, like you have the information fact sheet for matrimonial cases, do you ever create any precedents that you can then personalize and reuse?
Well, when it's based on telephone discussions and meetings with clients, it's harder to have a specific precedent that is going to be appropriate for every circumstance. So it's usually I will have a memo that I've done during that meeting, and then one of my staff will send a confirming email after the meeting or a phone call.
Excellent. Okay. Next question. What do I, as a lawyer, need to say to a client when settling a file? What does my client need to know? Ian, I think this is a good question for you.
Okay, so if you're discussing with your client and you're about to settle, you're about to go to trial, and you're wondering what you need to talk about and what you need to document, talk to your client about the possible outcome, the risks involved with each outcome, and the costs involved associated with each of those. So outcomes, risks, costs, and last of all, timing. You talk about all those things, and you have and you document, even if it's something as simple in your docket as discuss risks, outcomes, costs, and timing, that can help a lot if it ever comes to a claim against you. And just to follow up on Andrew's comments, even if you don't email your client, if you really don't have that time, as long as you write a nice note in your own file about it, that can help.
I just wanted to add one thing to Ian's comment. One of the things we like to do in our minutes of settlement or separation agreement is that if we've reached a compromise of two positions, we like to explain it in the separation agreement. So if we might say it's the husband's position, he's entitled to only pay $200,000. It's the wife's position that she's entitled to $400,000, and the parties have agreed on a compromise of $300,000 as they do not want to incur significant additional legal fees and perhaps experts' reports. Put that in the agreement. Put the agreement that way. That way a judge, if anyone's trying to set it aside, will understand the nature of the agreement, and the client will be reminded of it.
Excellent. Next question. We have lots of questions coming. Thank you. What do you think of limited scope retainers? Andrew.
As I said earlier, I'm all for them. More and more clients do not want us to do everything. They want to pick and choose what they want us to do. And if I have someone who's happy to pay me at my hourly rate, then I'm happy to do the work for them. That being said, in our retainer agreement, we have a tick box system so that if it is a limited scope retainer, we've clearly identified it, and don't go beyond your limited scope retainer without getting a further agreement with the client.
Excellent.
The only thing I'll say about limited scopes is this. When you are interviewing your client, you still must get all the necessary information. If your client says, I want you to just help me write this one factum, and that's clearly something where you're going to need tons of information, you still have to get all that information. Your duty as a lawyer doesn't get any smaller just because it's a limited scope representation.
Okay, and in the interest of time, the last question, what do you do when a troublesome client was not identified at the initial step of the client-lawyer relationship? So as the case progresses, the client has somewhat turned.
That's, quite frankly, that's going to happen. So the first step is you have to try and calm them down. That's where engaging in active listening is really important and demonstrating that you're sympathetic to them. But if they're still angry, then you have to tell them maybe you're not the right lawyer for them and have a challenging discussion in a polite and respectful way that they may want to take their business elsewhere.
Ian, any final thoughts?
Yeah, there's different ways you can handle this. One tip is to go to practicePRO.ca/difficult-client. There's a great article by the male Justice Carol Curtis about that. What I'll say, again, Andrew's a great people person, so I think he's able to massage the message quite easily. But for those of you that may not have that kind of subtleness, the very first time that your client yells at you or yells at your staff, you have to stop that immediately and say, I am not going to talk to you if you're going to be yelling at me, if you're going to be Okay, I got muted there. Anyway, I think I think what I said was pretty much it. The very first time a client mistreats you, you need to say right there, I am not going to tolerate this. This is a professional relationship. I'm only going to practice in a certain way, and you're going to have to abide by that. Don't let your clients bully you.